Good morning, this is your Kelso Report for Thursday, January 31st, and I'm your host, Clark Kelso. Our first case involves the propriety of testifying while wearing a disguise. We then turn to whether a non-signatory can invoke a contractual arbitration clause. Our third case involves the issue of whether a complaint adequately alleged an implied contract to pay retiree health benefits without change throughout retirement. And we close with a case involving a conflict between a grandfather's right of visitation over the objections of the father. Well, of course, we know that all the world's a stage, and all the men and women merely players. That may be true, but in a criminal trial involving a large drug deal, can a confidential informant who reasonably fears for his safety testify while wearing a disguise? Well, that was the question presented in United States v. Jesus Castaneda. Originally, the prosecution proposed that the informant be permitted to testify while wearing a wig, sunglasses, and mustache. The defense objected on confrontation clause and due process grounds, arguing particularly that the sunglasses might conceal facial expressions going towards his credibility, and suggesting that the court instead simply make sure he comes in through a secure location, secure door, and seal the courtroom. The court overruled the objection, and the informant ultimately testified while wearing a fake mustache and wig, but no sunglasses, so his eyes remained visible to the jury. On direct examination, the informant stated he was testifying in a fake mustache and wig, and defense counsel did not ask for a curative instruction, which would have informed the jury that they should not draw any negative inferences against the defendant from the disguise. The Ninth Circuit rejected defendant's argument that the disguise violated the confrontation clause and due process, because the disguise was necessary to further an important state interest, namely the safety of the witness, and there were sufficient assurances of the reliability of the witness's testimony, namely his physical presence in the courtroom, that he testified under oath, that he was subject to cross-examination, and that the jury could hear his voice, see his face, eyes, and facial expressions, and observe his body language. So in short, a wig and mustache do not violate the confrontation clause. Next we turn to a case involving arbitration. The slide's wrong on this one. Arbitration is a matter of contract, and a party cannot be required to submit to arbitration any dispute which he has not agreed so to submit. Similarly, a non-signatory ordinarily has no basis for trying to invoke a contractual arbitration clause against a signatory to that contract. The issue of whether a non-signatory could invoke an arbitration clause was presented to the Ninth Circuit in Kramer v. Toyota Motor Corporation, where the automobile purchase contract with the dealer contained an arbitration clause. The purchaser sued Toyota in a class action for misrepresentations and violations of the California Consumer Legal Remedies Act, false advertising, and breach of contract. Toyota then sought to enforce the arbitration provision. The Ninth Circuit affirmed the district court's rejection of the motion to compel arbitration. First, the court held that the issue of arbitrability was for the court to decide instead of for the arbitrator. As the court explained, given the absence of clear and unmistakable evidence that plaintiffs agreed to arbitrate arbitrability with non-signatories, the district court had the authority to decide whether the instant dispute was arbitrable. Second, the Ninth Circuit held that a non-signatory could invoke an arbitration clause only if the plaintiff's claims were intimately founded in and intertwined with the underlying contract. Well, examining the claims, the court concluded they were not so intertwined with the terms of the contract. Instead, the claims essentially focused on alleged misrepresentations contained in advertising and marketing materials, and the claims were not grounded in the contract between the dealer and the purchaser. So, the Toyota had no basis for invoking the arbitration clause. Next, we turn to a case involving retirement benefits. A very popular topic, of course, politically right now in California and around the country. In a decision that I think does send some shockwaves around the public sector, the First District in Iroquois versus Regents of the University of California reversed a demurrer granted in favor of the Board of Regents on a complaint alleging that the Regents' long-time provision of health care benefits to employees at the Lawrence Livermore Lab, plus what I would consider, and the court referenced as ambiguous statements in benefits booklets suggesting that health benefits would be available without change throughout retirement, created implied contractual rights that could be enforced against the university when the successor in interest of Lawrence Livermore Lab tried to change those rights after purchase of the lab by offering less coverage at higher prices. Now, several years ago, in answering a certified question from the Ninth Circuit, the California Supreme Court held in Retired Employees Association of Orange County versus County of Orange that a California county and its employees can indeed form an implied contract that confers vested rights to health benefits on retired county employees. After conducting an exhaustive review of basic principles of local government law, the Supreme Court held that a county may indeed be bound by such an implied contract. The court explained that although Section 25-300 of the Government Code requires that compensation of county employees be addressed in an ordinance or resolution, the statute does not prohibit a county from forming a contract with implied terms, inasmuch as contractual rights may be implied from an ordinance or resolution when the language or circumstances evidence an intention to create private rights of a contractual nature enforceable against the county. Well, the First District has essentially extended that decision and holding, so that the basis for the implied contract can include language in ordinary benefits booklets that are distributed to employees, and the mere fact that benefits were offered without change for several decades. There was no evidence in any statute, resolution, or other formal action by the Board of Regents that suggested an implied contract. The complaint relied instead on other communications to employees, and the First District agreed that those communications could be sufficient, even though they were at best ambiguous. Now, the First District's legal analysis may be correct, but given the importance of the issue, my guess is that the Supreme Court is going to grant review, so it can decide for itself just how broadly its decision in Retired Employees Association of Orange County should be read. Finally, we have a family law case. When a court gets in between parents and grandparents in visitation disputes, it can be easy to forget that the parents' constitutional rights predominate, and the court's role needs to be limited. That appears to be the error that the court committed in Ian J. versus Peter M., where the Fourth District reversed an order which improperly invaded the father's constitutionally protected right to determine who and under what circumstances other individuals may have contact with his daughters, who were 13 and 9 years old. The Superior Court seemed to think that the parent needed to demonstrate some grandparent misconduct or that visitation with the grandparents would be harmful. But that is not the law. Because a parent is ultimately responsible for the well-being of his or her child, and a fit parent is presumed to make decisions in his or her child's best interest, the grandparents in the case were required to show clear and convincing evidence that, notwithstanding the father's objection, extended unsupervised visitation with the grandparents was in the child's best interest. Well, the evidence in the case, which included the fact that both children did not want unsupervised visitation with the grandfather because of allegations of possible inappropriate behavior by the grandfather, that evidence came nowhere near clear and convincing evidence that unsupervised visitation was in the children's best interests. And that's it for today's Kelso Report. Have a great day in the law.